Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is Melissa Maxman, and today's topic is never a dull moment in antitrust? In the antitrust world, and perhaps to inflate our own importance, a number of antitrust practitioners have asked whether certain antitrust cases have become too complicated for, quote, generalist judges. For instance, a former U.S. DOJ Antitrust Division AAG, Megan Delrahim, once gave a speech entitled, quote, Specialist Decision Makers in and the Efficient Disposition of Antitrust Cases, in which he stated that, quote, complex economics underlie many cutting-edge antitrust cases, and asked, is the generalist judge or lay jury always the optimal decision maker for these cases? Regardless of your view on the average generalist judges, you cannot say that about our current guest, Judge Douglas Ginsburg, and we have the privilege to speak with him today. Joining me is my co-host, Anora Wang. Hi, Anora.
Hi, Melissa.
Who's our guest today?
Well, as you previewed, our guest is the Honorable Judge Douglas Ginsburg, who has been a judge of the United States Court of Appeals for the District of Columbia Circuit since 1986, including as Chief Judge from 2001 to 2008. In addition to serving on the D.C. Circuit, Judge Ginsburg is also currently a professor of law at the Anthony Scalia Law School of George Mason University, where he chairs the International Advisory Board of the Global Antitrust Institute and directs the LLM program in competition and regulation. Judge Ginsburg earned his JD from the University of Chicago Law School and clerked on the D.C. Circuit and for Justice Thurgood Marshall on the United States Supreme Court. Following his clerkships, Judge Ginsburg taught at the Harvard Law School and later served as the Assistant Attorney General in charge of the Antitrust Division of the U.S. Department of Justice. Through his careers in academia, government, and judiciary for 5 decades and counting, Judge Ginsburg made lifetime contributions to the antitrust law and policy, for which he became the 11th recipient of the John Sherman Award in 2020, which put him in company of Philip Rita, William Baxter, Judge Richard Posner, Judge Robert Bork, and Professor Herbert Hovenkamp, and such. So to quote the DOJ in presenting that award to Judge Ginsburg elevated the role of economic analysis in antitrust enforcement during his tenure as the Assistant Attorney General of the Antitrust Division. His jurisprudence and scholarship reflects the intellectual rigor that has marked his distinguished career. So, without further ado, I think we should welcome Judge Ginsburg to the program.
Well, thank you, Anora. Thank you, Melissa. Glad to be here.
Well, Judge Ginsburg, we are absolutely delighted that you made the time to be with us for this podcast. I know a number of our audience listeners are huge admirers of yours, and I'm one of them. And so getting to talk to you about your lengthy and really groundbreaking career in antitrust is a privilege. We're opening the episode with an open-ended question, which we want to invite you to comment on the work of your fellow jurists who perhaps don't have as many antitrust case experiences as you do. And can you tell us whether you agree with former AAG Delrahim that certain antitrust cases are best suited for specialist judges, and that a generalist judge should not be an appropriate decision maker? I should note for the record that about 10 years ago, you co-authored a paper titled Antitrust Courts, Specialists versus Generalists. So what's your verdict?
Well, first let me say that I want to distinguish between trial judges and appellate judges. We have empirical evidence on the work of trial judges with regard to economics in antitrust cases. And it appears in an article by Joshua Wright and Michael Bay, B-A-Y-E, that came out several years ago. And it demonstrated that the trial judges who had experience with a instruction in law and economics or antitrust economics specifically did better than their peers who had no such preparation. With regard to relatively simple cases, in the most complex cases, that difference broke down. So there's reason to think that bringing some economic education to the trial bar pays a dividend in terms of their ability to handle most antitrust cases. After all, most of them are not as overwhelmingly complex as some of the others are. Now, at the appellate level, there is experience not in the U.S., but in the United Kingdom, Canada, until a couple of years ago, India, all of which had created a competition appeals tribunal for the purpose of hearing appeals from the first instance competition authority. And those institutions, I think, were very cleverly and appropriately designed in that the judges, and I speak particularly of the United Kingdom Competition Appeals Tribunal, those judges were not just sitting on that tribunal. They were general jurisdiction judges from across England and Wales who would be seconded to that court for a period of several years, perhaps 5 or 7 years. And the court would hear perhaps 40 cases in a year, and so each of the judges might sit on 4 or 5 of those, or maybe 7 or 8 of those cases. And over a period of just a few years, I think it's quite evident that they would acquire familiarity, comfort level with the materials, with the economics, without the pitfalls of being a specialist, which are to say isolated from other developments in the law, sources of other ideas, observations that come only from having a broad jurisprudential portfolio. So I think that design is very clever and is worth experimenting with. We've had a couple of specialized courts, well, we still do, but we've had many over the years that were lived out their usefulness. We have the Federal Circuit, but the Federal Circuit has both tax and patent jurisdiction, and it's frankly inconceivable that any one individual could really be a specialist in both those fields. I mean, most of the judges come from one field or the other, and they do their best to pick up what they need to know in the field where they didn't have a background before they joined the bench. But that's very daunting. I think it's sort of a halfway house between having a real specialized court and having a more general jurisdiction. Then there were things like the Temporary Emergency Court of Appeals that came out of the Korean War and lasted for 30-odd years because I think people vested in the institution couldn't stomach the idea of giving it up.
Right.
Institutional momentum and the observation that there's nothing as immortal as a government agency may have been at work there.
Right.
But so I don't know how successful that was. But I mean, we've had some experiments with this. It's not an infinite commitment, and I think it would be worth delving more deeply into the possibility of a specialized appeals tribunal, again with generalist judges who spend a certain amount of time on that bench.
That's fair. I think your answer might have set up for my next question, which is no one can be expert of everything. And just to focus on your own career a little bit more. So would you consider yourself as a specialist in antitrust, but a generalist in some other fields like tax? Maybe not patent because you're so deep in the SEP and FRIEND world. But so do you approach these cases differently? Antitrust versus another field that you are not as deep in the weeds in?
Well, I hear antitrust and even more significant in numbers, competition cases coming from regulatory agencies, federal regulatory agencies, many of which have jurisdiction to make competition decisions. And so all of my colleagues get experience in that because we hear about 35% of our cases come directly from the agencies, and some percentage of those every year involve competition issues. So this court is really, the D.C. Circuit is really a court of administrative law and to the extent necessary, whatever subject matter comes up, competition matters, energy, and so on, and they recur. So we all gain some familiarity with each of those fields. Now, I teach antitrust and have done for most of the last 40 years, and so I have perhaps more, settled views or more current views than someone who just encounters a case every year or two or a couple times a year. But in a collegial body, that's not a great advantage. My comfort level is high, but a federal circuit judge has no authority whatsoever without colleagues. I mean, we can't do anything individually. Everything has to be done through a panel of three, even if there's somebody who's later recused or passes away or what happens, we have to have a panel of at least two just to complete the task. No one here can do anything on his own.
Right. Now, I'm just trying to put myself in your shoes, and definitely this is a hypo. Like, if you have an antitrust case coming up and you have your excitement, and because you have been experienced and as you said, your tolerance level is high, and you've seen a complicated antitrust that really excites you. But is that like, speaking with because when you arrived on the DC court, you have had years of antitrust experience from your agency work experience. But do you have some ideas on specific areas in antitrust that you thought maybe the case law should be changed or pushed or reshaped a little bit? Did you have any such moments when you see a case like, aha, this is the case I wanted and waited for?
Well, if you look at my writings in the field, and I do write a lot, not necessarily no treatises or anything like that, but a large number of often relatively short articles. that do not begin with the history of competition law from the Phoenicians through the Romans to the present, that go directly to the matter at hand. There have been things that have come up in the commentary world, not necessarily in the court, in which I've taken pretty clear positions. I think one of them just a few years ago was about all the excitement with regard to so-called patent trolls, which are really non-practicing entities. That is to say, they don't practice the patent, but they license it, they acquire it perhaps, and then license it to others. And it's simply an efficient division of labor for one firm to specialize in enforcement, another firm to do the innovation, and then transfer the enforcement function to a more specialized firm. And it's just a simple observation. It's no more complex than the pin factory in Adam Smith's Wealth of Nations. But there was a groundswell of academic and practitioner literature hysterical about patent trolls, so-called, derogatorily. I mean, the University of Wisconsin is a non-practicing entity, and I don't know, why they would want to call them a troll. They develop patents, or their faculty does, and they license them. So that resulted in, not my article, but that debate that was going on, resulted in the FTC doing a market review, a 6B study, which was quite useful. It was based on survey evidence, and it basically put the issue to rest. I mean, that was a good service to the community to end that quasi-hysteria. Or another one was the idea, which bad ideas almost never die, They just come back in another form, or if you wait a while, maybe not even in a different form, because young people don't know what's been around. Was the idea of someone who holds a standard essential patent seeking an injunction to enforce it, thereby being guilty of an antitrust infringement because they're seeking an exclusion order at the border or an injunction against further infringements of their patent. Of course, these are preliminary. This is preliminary relief, so there hasn't been a trial on the merits of the patent or its validity. And the idea that seeking an injunction could be deemed an antitrust violation, I thought was among the stupidest ideas I'd ever encountered. I mean, first of all, you don't get an injunction by the way you get an apple off a tree. You get it from a court or from the ITA if it's an exclusion order, and you have to show a lot of things, including that the harm to you not getting the injunction would exceed the harm to the counterparty of there being an injunction, that the public interest would be served by the issuance of the injunction, a couple of other factors, and now actually several more factors under that case a few years ago in the Supreme Court. What's the name of it, Anora? The eBay factor.
Oh, yeah, eBay factors.
So,
yeah.
The idea that seeking a relief under your rights in the First Amendment, as established in the North Pennington cases, could be an antitrust violation, was just absurd. And it went away, at least for a while. It won't be long before it's back if I hang around long enough.
A percentage of our audience members might be sending us some feedback. You're welcome to send us whatever you think of that statement.
So, that's not something that's come up in the court in a case. I was trying to head off a dumb idea before it became the subject of misshapen enforcement actions.
Right.
And I had something recently, a couple of years ago, with Cohen, Wang, Irvin that we wrote about on challenging consummated mergers under Section 2 and the implications of the Microsoft precedent for that.
Right.
So that actually, conceivably could come up, but in litigation, but I don't think it has.
Well, you anticipate
simply to say, what I think what we'd have to actually prove, and there were some people going about thinking this would be very simple and that harm could be presumed. Whereas I think because of the 19 pages devoted to demonstrating the harm in the Microsoft opinion, that was not a well-founded reading of the case.
Well, you anticipated where we were going next. Speaking of recurring issues in the antitrust world, one of your most influential cases, as you know, was the United States versus Microsoft decision in 2001. And it remains foundational to the understanding competition in high-tech markets. And as we discussed on our prep call, I was one of the litigants in the Microsoft case, was the private litigants. And this case has been widely studied, especially now in light of a number of the high-tech companies being challenged by the government and by private parties for their alleged monopolistic behavior in a certain field. And so from the perspective of 2 decades later, what can we learn from the Microsoft case that we can apply in the cases that are now pending or about to be pending or being investigated by the government agencies, both the FTC and the DOJ?
Well, first, let me remind you, well, as you know, Melissa, that was a court of 7.
That's true.
The decision was issued en banc.
Right.
So,
that is true. And it was per curiam.
So you can't blame it all on me.
Well, let's put it this way.
Only the good stuff.
I know you didn't, it's per curiam, but I think given the makeup of the court at the time, you probably were the specialist judge.
Well, I don't know. That's a long time ago. I'll tell you, though, one important fact, I think, is that we were 7 judges instead of the 10 or 11 that would have been eligible because of recusals on their part. And so the question arose whether to hear this case en banc from the outset or to let a panel decide it and then subject to rehearing en banc. And there were 2 possible reasons for holding it en banc from the beginning. And the one that I found persuasive was that under the rule then in place, rehearing en banc required a majority of the active judges, notwithstanding their recusals. And so if it were 10 or 11, 6 judges would have been necessary to hold the matter en banc. And if you had a panel of 3 on a court of 7 hearing it, and if it's a divided panel and it's 2-1, there's no way you're going to get, or even if it's not, there's no way you're going to get 6 judges. There aren't 6 more to go around.
Right.
And the idea that a case of great potential importance and with a 70,000-page record that was not ready for the Supreme Court, I mean, it had to be intermediated, going directly to the court en banc, I thought was essential because we just couldn't have a panel of 3 judges, potentially a divided panel of 3 judges, resolving a case that was impractical for the Supreme Court to deal with. It would have overwhelmed them. So the case got narrowed quite considerably, and then of course it was settled. But had it gone to the Supreme Court, it was made manageable in much greater degree. Well, I mentioned that I think what the standards are for challenging a consummated merger. I think under Section 2, that is. Section 2 has been used before in some monopolization cases, but not for quite a while, and not in the high-tech area. And so one of the things that I think I was cognizant of, and I think everyone was, that, well, for one thing, we would not accept the government's proposition, that tying, in that case technological tying, should be deemed per se unlawful. The whole idea of per se illegality is that experience shows that these cases always come out one way, and you really shouldn't be going through the onerous process of trying each case to determine whether, let's say, a cartel was bad, was anti-competitive. Right. And that just isn't true when you're looking at what is essentially the first high-tech case involving technological, or maybe it was the second, technological tie-ins. And I think that is still the case, frankly, that no one has thought we have enough experience to counter that now. You might notice, if you go back to that, beyond the Microsoft case itself, that the allocation of burdens in that case and the sequence in which they would be entertained, resolved, has a more than superficial similarity to Title VII employment discrimination cases under the Supreme Court's McDonnell-Douglas allocations. And I think that, which was new in Section 2, was something that just kind of came naturally to the thinking of the court, because everyone's familiar with these Title VII cases, and it seemed like a very sensible way to think about the matter. And I think Professor Elzinga had already written something to that effect.
Right.
Not invoking McDonnell Douglas, but simply talking about the pleading requirements. Yeah, I'm sorry.
Yeah. Oh, no. I just want to dive in a little bit into your thinking when you were dealing with Microsoft case a little bit. I feel like in areas like antitrust law, when a lot of the important issues are actually decided in case law, in actual litigations, I wonder a judge sitting on that case at the time could have become like almost too self-conscious when handling such a case. Did you know when, like, obviously when it was so watched closely by so many at the time, it's an important case, but did you think, like, in the long term, what that case could have impacted in terms, like, the development of antitrust law?
One never knows, and it's a mistake to think about it.
Oh, okay.
Some cases have a very short half-life, and others for exogenous reasons, and others end up being quite important. There are cases I've had in which the background to the case and who was really behind it was unknown to me until I read it in the newspapers after our decision was issued. I mean, the case about the Patent Term Extension Act, which involved, it was called the Sonny Bono Patent Term Extension Act. And it culminated in a case in the Supreme Court written by Justice Ginsburg under the name of Eldred, E-L-D-R. I think that was the name here too. And there was a group of 7 different parties who claimed standing for some reason to protest or on the other side preserve this patent term extension. And only when the case had issued and it was in the newspapers did I read that it was Disney that was behind the case. And it was the mouse that was at risk. 75 years was coming due.
Right.
So, if you start thinking about it in those terms, you'll almost always get it wrong. You don't know what there is that's not in the record.
Right. I'll keep that in mind. In our prepping call, you actually raised a point. I think that's interesting and important, which is that in DC Circuit, sitting where it is, actually, the DC Circuit didn't get a great variety of antitrust cases. Here in DC, agencies may come to you for injunction, probably to stop contemplated merger, perhaps, but many conduct-based cases that we have been hearing about are brought where business operators, such as in New York and California. But does this fact make you even more specialized with antitrust cases involving federal agency enforcement?
Well, for one thing, both the agencies, Antitrust Division, Department of Justice, and the FTC, are frequently in our district court seeking a preliminary injunction. Mm-hmm. And some of those cases do get appealed. Not a lot, but some of them do. And then the matters that come up from the regulatory agencies are in many cases indistinguishable from a case that could have been brought by one of the agency, but for the fact that the Congress assigned the jurisdiction to the sectoral regulator. So I think we end up getting more than our fair share of competition issues, even if the FTC and the Department of Justice and Antitrust Division are not here as regularly as they are in New York Southern and California Northern District.
Let's turn to the agencies, because as you noted, the D.C. Circuit is the Court of Appeals that the administrative agencies are permitted to appeal directly to. And some are arguing now that agency antitrust enforcement should be done with the purpose or intention of developing good antitrust law. Do you agree with that proposition? And do you think cases have been under or over enforced?
They have to make decisions. They have to choose what cases to bring. It doesn't serve their interest to bring cases that are born losers. Right? But there's certainly long history of testing the edges of existing case law. Although I think most of that's done much of it anyway, by private parties who, the agencies bring fewer than 5% of all the antitrust cases, the enforcement agencies. The rest are private cases, including class actions and non-class actions. And the body of law vitally depends on the outcome of the cases brought by the 95% brought by private parties and how they're received by the courts around the country. So, the government is the agencies, or the FTC specifically, can be a player in that. In the cases of the reverse payment case that went to the Supreme Court, starts with an A. What's the name of it?
Activists.
Activists. The FTC had brought several cases in different circuits. There were private cases, I believe. There were 3 different rulings in 3 different circuits, and that had to be obviously resolved by the Supreme Court. So, private parties, of course, create conflicts too, and get the Supreme Court to shape the law, considering the loyalty programs. So there's Peace Health, the West, in the Ninth Circuit, and then the Third Circuit case. Which one is that? In which they have very different standards. So those are both private cases.
Let's change gears for a minute and turn to your scholarship. And I know we discussed when we were preparing this podcast that you and Professor Josh Wright have a forthcoming publication studying non-antitrust federal agencies getting involved in antitrust-related decision-making. Do you want to talk a little bit about that? Can you tell us a little bit about what to expect when it comes out?
I think one of the important issues, is there's 2 very important issues. One has to do with the very wide distribution of competition jurisdiction, some of which is plenary, that is to say, where the agency makes a decision on its own based on criteria that have been put into the statute it administers directly or by reference to the antitrust laws. And in some cases, the agency, as I say, has the plenary authority. In others, it must first consult with the Attorney General, which means the Antitrust Division in practice. In others, it must consider competition among several factors that guide its decisions, or that are supposed to. And the performance of the various agencies, in particular looking at where they have had plenary authority, is not not uniformly satisfactory. I'll take an example that where there's where the agency has lost that jurisdiction, so it won't be happening again. But from 1938, when the Civil Aeronautics Board was created, until 1978, Congress passed the Airline Deregulation Act. I don't think the CAB ever rejected a merger proposal, and they never allowed a new trunk carrier into the system using a license to operate. And so they started with a certain group of trunk carriers and ended up with a smaller group at the end of their lives. And under the 78 Act, the jurisdiction was transferred to the Department of Transportation, and its performance was so abysmal that in 1989, the Congress sent it over, I should say, to the Justice Department.
Right.
I mean, it was, and some of the airline mergers that were approved by DOT they would never have passed muster, and several of them were opposed by the Antitrust Division in filing comments before the DOT, but they were powerless to control the outcome. It was amateur night, and that just shouldn't happen. And having corrected the situation, the Congress having corrected the situation there, doesn't mean there are other situations that ought to be similarly folded back into the jurisdiction of the Department of Justice. So that's certainly one. Now it has to vary. I mean, there may be an agency, and I'll take an example. I'm not sure this is correct, but I think one possibility would be the bank regulators, who often find themselves having to initiate a merger, force a merger, or approve a merger overnight or over the weekend. And competition is not the most important thing in their book, and really in anybody's who's familiar with the situation. So, and there isn't time to be taking comment or even asking the Attorney General. They just have to do what they have to do in those circumstances. Now, maybe not all the cases are like that, of course. So maybe the department could have a greater voice on the cases that are not under time pressure.
Right.
So, we can't have a blanket prescription for this, but rather, I think, a real need for further inquiry and adjustments.
Yeah. So when are we expecting to read the publication?
Well, that depends upon the gods of the Antitrust Law Journal, by the Antitrust section of the ABA. So you're in a better position to tell me.
Well, listeners, stay tuned. So, Judge Ginsburg, your antitrust scholarship is widely admired, and I think we talked about some of that. We talked about the agency enforcement. We talked about SEP and FRIEND, but your academic work, tackled really complex questions ranging from, what we talked about in intersection of IP and antitrust, but also touches upon effects of extra-jurisdictional remedies and something else. A lot of are on institutional design level, I think. So just to round out a little bit more, do you want to talk a little bit about your scholarship in some other areas that also touches upon institutional design, perhaps extra-jurisdictional remedies?
Well, yes. My colleague Josh Wright and I have written about consent decrees in which the agency, and this includes states of the United States and member states of the European Union, have extracted relief that they could not have obtained in court, and in many cases because it's anti-competitive. And so we have a compendium in the appendix to one of our articles with chapter and verse on cases in which, let's say, medical practice is merged into a hospital in a non-urban community, and one of the requirements in the settlement is that the resulting entity not employ more than X% of the doctors in a certain specialty in the county without coming back and getting permission to do so. Just purely anti-competitive. Or obtaining relief that is, I think, could never have been obtained in court, even this is a couple of cases that the FTC settled in the early 2010s, involving the licensing of standard essential patents, and Motorola Mobility and whoever the merger partner was did agree, I should say, not to seek an injunction to enforce their standard essential patents anywhere in the world.
Yeah.
And there had never been a litigated case on this. It was, the agency had a theory, and they had the coercive power over, as they have over a merger, to extract all of the
Right.
rent that might ever accrue from it. And it looks to me like that's what all that they were doing. I can't imagine that a court would have approved that.
Yeah. Just to harken back, we previously did an episode on the whole dance of anti-suit junction and anti-suit injunction.
Yeah.
So if listeners are interested, you can find it on our website of that episode.
I would like to do that. Tell me later on how to do so.
You can send it to you.
Please. Yeah, so this is an issue that was really foisted upon the rest of the world by China, working on lecture now on licensing of standard essential patents. And Chinese courts, and this is well documented in a forthcoming piece by Jonathan Barnett, Chinese courts have imposed very low royalties, much less than was sought by the patent holder, and imposed that royalty worldwide, which is not necessarily use of authority. UK court did that in Unwired Planet.
Right, exactly.
But also enjoined the patent holder from seeking a greater royalty anywhere else in the world, and from seeking an injunction against enforcement of the Chinese court's order.
Right.
And that eventuated in at least one anti.
Yeah.
Several others, 4 or 5, involving anti-suit injunctions. And, it's a lot easier. It was, as a few years ago, a lot easier to get an injunction against infringement of a patent in Germany than in several other countries. And so people would commonly seek an injunction there, even against enforcement of the Chinese court. Well, you can't we just can't say as a blanket matter that what the courts there are doing is inappropriate, because we have standards for when we will defer to the rulings of another country's courts in competition matters. The most recent being in the Supreme Court just to the 2021, in the vitamins case.
Vitamin C case, yeah.
Yeah. And so, we have these complex standards. And when that went back to the Second Circuit, the court enumerated 10 factors to consider, which I believe it said all 10 favored deference to the ruling of the Chinese court on a factual matter as to whether the conduct of the defendants in our antitrust case, Chinese companies, were colluding under state coercion or simply like any other cartel. So we just can't make a blanket condemnation of what the courts in China have done, but some of the cases seem to be really mercantilist protection in keeping with some party decrees.
Right.
About that's hardly a definitive statement on my part. I mean, it's something that's a concern, and one way or another, we're going to have to work this out among nations. Now, there is a complaint before the TO brought by the European Union. So we'll see where that goes.
Yeah.
So thank you so much for your insights. We have we're going to turn to the final portion of the podcast, in which we ask you some personal questions, not too personal, to give our listeners a better feel for you as a person. And so the question that we start by asking is, can you tell us something about you that people don't know if they only know you professionally?
Yes. Recent vintage, I guess, until about 5 years ago. Well, and I put it another way, 5 years ago, I completed my 23rd season of mounted fox hunting. Mostly in Virginia, some of it in England. It's the only sport in which I've ever been deeply engaged.
I heard people in fox hunting actually don't kill the fox. You just like
Not
to
in
ride
the United
horses
States.
and chase the foxes.
Yeah, not in the U.S. It's fox chasing in the U.S. The U.K., historically, they did kill foxes because the foxes killed about 7% of the lambs every spring. So the farmers wouldn't let you run over their land if you weren't helping them. Here, the equivalent would be a coyote. And I have been in on a kill of a coyote where a brace of male and female were loitering outside a cow and calf field, and they were fixing to take down a calf. So the farmer was suitably grateful for that intervention. And then in 2004, the Hunting with Dogs Act passed in the UK. And now, instead of, when the fox goes to ground, instead of allowing the hounds to ferret it out and kill it, which is actually not inhumane because the first hound breaks its spinal cord, and they now flush it out with a terrier and shoot it, which is okay if it's a true shot. It usually is. But that was done in the name of animal welfare. But the result is that there are foxes all over the garbage and parks in London.
I see.
The
Rat foxes, right?
Completely out of control. Yeah.
Yeah.
But we just don't have those problems here. We don't have a lot of sheep. We don't have fox hunting where we do have sheep. We don't kill the foxes. We say, thank you for a nice ride. We'll see you next time.
Right. That is fascinating.
So then the thing goes much further back. In 1965, two fellows who were they were juniors at Harvard College, and I had taken a leave from Cornell. We started the first computer dating company in the world.
Oh.
And ran that for about 6 years. I was in it for 3.5.
You could have a very different life perspective, right?
But the technology then, of course, was very primitive. I mean, by today's standards, the computers were using tape decks. I mean, they hadn't even, before I left, we got into random access memory. But tape decks were extremely and punch cards. We had the economics of it then were because of labor cost. It was common to ship punch cards to Korea for punching. Now you ship the written data or the paginated data to Korea, where somebody would punch it into a machine that punched the cards and ship it back to the U.S. And Korea was great because we don't have the same characters. And so they didn't get distracted by real words. It was all arbitrary things like random numbers would be. And so they were much more accurate than people who shared our alphabet.
Wow. Did you have a name of the digital platform that you had developed?
It was Operation Match.
Operation Match.
Yeah, and it was the company behind it. Our company was Compatibility Research Incorporated. Started out as a social relations project for one of the fellows who was at Harvard in that field.
Wow. How did you feel when you watched the movie The Social Network?
Yeah, well, if only I stayed with it or something. No, the technology just wasn't up to what Zuckerberg was, really ingenious.
Right.
in starting it when it was much more practical to do it on a big scale.
Finally, do you have any particular advice for young professionals or students who are interested in going into antitrust law or in being a judge someday?
Well, in antitrust law, certainly. Yes, I have a lot of clerks, who have gone into antitrust. And I now have half of my clerks as antitrust specialists, let's say, or have a special interest or practiced or worked for a litigation support firm before they went to law school, things like that. And so they're sort of are naturally committed to the field. But the others, and I've said this for decades, and even if it's not just specific to antitrust, go into the Department of Justice if you can, after clerking or after law school. Because it's not, you don't get another chance for a long time. If you don't get hired in the honors program at the Department of Justice, coming off a clerkship or right out of law school, you probably won't be going there until you're at a policy level, coming in as a assistant or a deputy assistant to some division chief. So that's a lot of years in between. And there are obviously exceptions from time to time. The Antitrust Division has brought in senior practitioners, which I think is demoralizing, frankly, for the staff. And it's not often done. It was done in the early 2000s and then again once since then. So it's an opportunity that probably won't come again, or your opportunity cost will be too great to accept it, after 10 or 15 years. So get it now because the experience is invaluable. Unlike, I don't know how things are in big law firms now, but they used to be very structured in terms of when an associate was allowed to defend a deposition, when it was allowed to take a deposition, and so on. And it could be several years before one could take a deposition. In the government, there's no standing on ceremony. They're not there to waste. They don't want to waste talent. So people get skills much faster and experience much faster.
Well, thank you so much, Judge Ginsburg, for spending this time with us today, giving us a glimpse of your personal life and really educating us about the workings of how the antitrust sausage gets made.
Well, I hope I didn't do that.
Well, we really appreciate it.
Well, thank you. I enjoyed talking to you.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.